First, we'll take a photo of the court for record purpose. So we'll take a photo of the court. Right. Tell us when you're ready, so we can smile. Yeah. Thank you.
Court of Fiji, its original jurisdiction, contribution hearing of miscellaneous section number 1 of 2025, in the matter of a reference by the Cabinet for an opinion from the Supreme Court on a matter concerning the interpretation and application of sections 159 and 160 of the Constitution of the Republic of Fiji.
Thank you. I take it all the counsel for the parties are present. Right. Then, Dr. Butler, over to you.
Nisa Yandra Vinaka, my lady, my lords. I'll try and go slow because I find often transcribers find my Irish accent a little bit challenging, but I may at certain points get a bit excited and speed up. So if I'm going too fast, please, Your Lordship, the Chief Justice, a hand signal. My lady, my lords, this is an important moment in Fijian constitutional history. I want to acknowledge the approach that has been adopted by my learned colleagues who have brought passion, insight, and learning to these difficult issues. My role today differs from theirs. Each one of them has a client. They operate on instructions. My role is different. I am Amicus curiae. That's a Latin term, means friend of the court. The function of an amicus curiae is to ensure that arguments are made before the court that might not be made by other parties to the litigation, but which should be made for the just determination of the matter before the court. To ensure that arguments before the court lay out a range of options that may be available to the court in expressing its opinion on the matters referred to it, and to ensure that the court's attention is drawn to authorities and scholarly writing that may be of particular or general assistance to the court in the determination of the issues before it. So it's important, I know your lordships understand it, and my learned colleagues understand it, but it's important, I think, for those who are observing this proceeding outside of this room, that it is understood that in discharging my role as amicus curiae, I am permitted to advance arguments that may appear to have contradictions. As in, I don't need to be consistent when advancing arguments. My job is to assist the court at any number of different levels with particular arguments. That's because I'm not representing a party. I'm here to help the court. If the court asks me for what my opinion is, what I would do, I'm happy to give that. But that is not my primary role here today. It's to assist you in that you're thinking and testing propositions that have been put to you by the other parties and thinking that has taken place between discussions amongst your honours, to the extent you're happy to share those with the court. So I see my role as being to provoke and prod rather than simply to advocate for one particular position. Seems to me, having listened to the exchanges over the last 2 days and having read multiple times the submissions that have been filed by the other parties, that there are some core issues for the court to address. And I'm going to address the issues really in reverse order from the way in which I addressed them in my written submissions. I think it's become obvious over the last 2 days that there's a conundrum that faces the court, and that just needs to be acknowledged. So that's the first issue I want to confront. The second issue, which arises from the existence of the conundrum, if I'm right that the court has identified a conundrum, is what the court's proper role is in responding to or resolving that conundrum. That leads us to exploring what options would be available to the court on this referral, bearing in mind it's a referral for an advisory opinion rather than a proceeding in which orders are made that bind particular parties. There is an issue as to the relationship, if I can express it broadly, between the 2013 Constitution and the 1997 Constitution. In short, is the 1997 Constitution still in play? Or has it been successfully superseded by the 2013 Constitution? I come then to jurisdiction on a reference, on a referral. And then lastly, I come to what should the court do? I will have, if I have time, a number of miscellaneous matters that I would like to address that have arisen during that discussion between the bench and counsel. For example, yesterday there was an exchange about adjudication in constitutional matters and the difference between adjudicative facts and legislative facts. That may not be an issue which is ultimately dispositive in this case, but some views have been expressed, and there are important issues of general constitutional litigation which might arise, which I feel I should address if time allows. But I want to not get distracted by the many potential issues that could be addressed in this most interesting and difficult case, but try and assist the court by really zeroing in on what seem to be, as I apprehended, the issues that the court is troubled by. So that's the outline, Your Honours, of how I propose to assist you. If I could start then with acknowledging the conundrum, or addressing the conundrum. I think what the parties and the court have been exploring over the last 2 days is what I am referring to as a conundrum. Others may refer to it as a dilemma. The conundrum, as I see it, is this. The entrenched constitutional amendment provisions make the 2013 Constitution one of the more difficult to amend relative to overseas constitutions. And I think I've been reasonably upfront in my submissions, all of my submissions, in suggesting that the amendment provisions here are at the top end of the spectrum in terms of difficulty of amendment. But that is not of itself a cause of concern, and I think that's an important proposition that I put before the court. The fact that a constitution may be difficult to amend is not of itself a cause for concern. When I come later in my submissions, I'm going to take you to a number of examples of constitutions where...
Were they democratically...
That's where I'm coming. This is the conundrum, sir. So as always, Your Honour's ahead of me. But it's very important that I emphasise that the cause for concern is not in and of itself the difficulty of amendment. There are many constitutions that are difficult to amend.
It is affected, though, isn't it, by content?
Yes.
That many constitutions make it difficult to amend the fundamental features of the constitution that you want to associate with the country. The unusual thing about this constitution is A, it covers a very wide field, and B, it is difficult to amend anything, not just the fundamental features.
And Your Honour has it. So that's where I was coming. So let's put a little tag on the point Your Honour has made. And obviously a tag, which I'm coming to almost immediately on the point that His Honour, His Lordship Justice Young has made. Because I think, just to flag, I think at one point we're going to have to get down to brass tacks if the court is going to do something here, and we need to get down, I think, to some of the detail around the brass tacks and figure out what it is that the court can or cannot do, either itself using an instrument like this, or simply using its voice to express concern. Just to flag how I'm going to suggest you might wish to tackle what the options are. But I do think it's important that people in this room and outside the room hear that the difficulty of amendment of a constitution is not itself necessarily a cause of concern. The cause of concern, the real problem here, and I think it was Your Lordship, the Chief Justice yesterday, when submissions were being made, I think by Mr. Moses, about saying, or maybe it was the Fiji Labour Party, I can't quite remember now. I don't have a copy of the transcript from yesterday, unfortunately. But one or other of the parties made a comment about, well, difficulty of amendment and so on is not unusual, to which I'm sure it was Your Honour, Your Lordship, the Chief Justice, who said, yes, but don't we need to see what the context was, how it was that these provisions came into being? And I think that is at the heart of what I'm describing as the conundrum. It is, to use the language of some of the parties, it is the fact that these amendment provisions are in a constitution that was, some people have used the word of, imposed. If the court doesn't like such a strong word, one can use a word of saying in respect of which popular participation.
It was imposed by an autocratic government without democratic consultation and by decree.
Thank you, sir. So then I'll just use imposed.
Yeah.
So the problem here is that the 2013 provisions were not adopted as a result of a deliberate decision of the people of Fiji expressed through their representatives or by, for example, a referendum. How, therefore, can imposed hard-to-amend constitutional processes be allowed to, in effect, handcuff the people of Fiji? Now, a number of solutions have been suggested by the parties, and I think it's helpful to just summarise them, and I don't mean any disrespect by not dealing with every one of the proposals that have been made, but I just want to recall the array, the smorgasbord, if you like, of solutions or potential responses that have been put before the court. So the state's answer to the conundrum is that the court should declare Chapter 11 inoperative. There are, with respect, macro and micro problems associated with this stance. At the macro level, it would result, at the macro level first, it would result in the Constitution ceasing to be a supreme law in any conventional constitutional sense. And that was a point, I think, that Your Honours, Justice Arnold and Justice Young made in exchanges with my learned friend, Mr. Walker. 2, the Constitution ceasing to be the supreme law would in turn be contrary to the core provisions of the Constitution. Sections 2, subsection 1, Section 2, subsection 2, which declare the Constitution to be the supreme law and declare that any law inconsistent with the Constitution is invalid to the extent of the inconsistency. 3, it would be contrary to Fijian constitutional history, which has always had entrenchment and some form of supermajorities. And it would be contrary to the plain intention of the framers that this constitution continue that tradition of entrenchment. Micro issues would include, for example, the following. If sections 159 to 160 were ineffective, the result would be that there would be no explicit power to amend the rest of the Constitution. And of course, at a micro level, it would render section 2, sub 2, and more particularly section 2 sub 5, meaningless. In the case of section 2 sub 5, it would mean that there in fact would be no chapter 11 that prescribes amendment procedures. So my suggestion to the court is that the outcome advanced by the state is not one that is plausible for this court to adopt. Now, in recognition of this, the state has suggested that the failed 2025 Constitution Amendment Bill provides the solution. State Council says that the government, and here I'm quoting from the transcript A1, page 20, will give close consideration to presenting the bill without a referendum to the President for assent. And that is doable, my word doable, but just to shorten things, that is doable because the bill is, quote marks, sitting in limbo at the moment, end of quote marks. Transcript A1, page 21. But there are problems with this way of proceeding. First, the bill is not in limbo, it's dead. It was defeated at second reading. Hansard, 11 March 2025, page 441, in the casebook at page 2797, motion defeated. That means the bill would have to be reintroduced again. Second, Cabinet cannot bind Parliament. Separation of powers applies. The government cannot commit Parliament to enacting particular legislation. Any commitment by Cabinet would not be enforceable. This court would not enforce any such commitment against Parliament if Parliament were to enact a Constitution Amendment Bill that differed from that which failed in March this year. Third, the submission presupposes that the 2025 bill is a done deal. Even though the people of Fiji were not consulted on its content, nor has there been public consultation as part of the parliamentary process. Had the bill passed its second reading, it would then have been referred to the standing committee, which would have been the 6th committee, which deals with justice matters. If you look up standing orders, it's the one that deals with matters related to the Constitution. If you look at standing orders, and I don't know whether they are the full set is before your honours, but I'm sure I can organise for those to be provided in due course, but they're easily Googleable. If you look at standing orders, committee processes involve public consultation. And you would expect on something as momentous as a Constitution Amendment Bill that the public would be interested and might have much to say. The public, for example, might wish that any Constitution Amendment Bill adopts a variegated approach to constitutional amendment, picking up on the theme put to me by Justice Arnold. So it could be that the amendment of certain provisions can take place through, let us say, a 2/3 supermajority requirement, but in contrast, an amendment to the fundamental values of the state set out in section 1 and or say section 2 and 3, let's just add them in just as examples, that those should be given extra special protection as is common in many other constitutions, such as, for example, South Africa. And just noting while I'm there, the South African Constitutional Court, when undertaking the certification of the 1996 Constitution, insisted that in order to comply with the constitutional principles that applied to the making of the new Constitution, that there should be a special protection for those sorts of provisions. Indeed.
Can I just make some reference to earlier constitutions? The one-
Please, Your Lordship.
In two of the earlier ones, we had special entrance provisions only for those that are listed in certain provision of the existing constitution. I want to ask this question, since you are raising it now for the first time, I haven't heard it earlier. Are you saying that at some stage we need to consider the idea of engrafting the concept of the basic doctrine into this?
It's a very valid question to ask, my Lord. I've said in my written submissions that the court probably doesn't need to go there on this reference, but may wish to signal
Yeah.
that there are basic features that this court would insist on going forward.
Yeah.
And that would be consistent with, I apprehend, the direction in which the court may be moving in answer to the questions that arise on this reference.
Thank you.
And that's why I covered the basic features doctrines in my written submissions, because I felt it was appropriate for the court to be across what basic feature doctrines involve and the fact that they are highly contested. There are important common law jurisdictions that adopt them, but there are important common law jurisdictions that have rejected them. So the last point I just wanted to make in terms of the point I was making in terms of public involvement, in terms of consultation on any newly introduced constitution amendment bill, because it's a very important point, I think, is there would be an irony, would there not, in the idea of this bill being taken out of limbo. As I said, it's not in limbo, it's dead, but being resurrected and simply sent to the President for assent without proper, full public consultation, particularly bearing in mind that the object of the exercise is to enable the people of Fiji to participate in the amendment of their constitution. So the fourth point I wanted to make in response to the suggestion made by my friends for the state is that adopting the approach advocated for by my friends seems to me to be contrary to the way in which a court would go about interpretation and application questions that come before it. In other words, the interpretation or application task for the court begins and ends when you say what the Constitution means. What the state is saying is you should say that the Constitution means that a simple majority of Parliament is all that is required to amend the Constitution. That is how you should interpret this Constitution, applying a number of the techniques they put forward. But don't worry, that won't expose the polity to danger, a danger which they implicitly acknowledge, because there are steps that we say we might take, but which no court can order be taken, no court can make happen. Now, my friends for the NFP, they propose that the 3/4 of MPs become 2/3, and they oppose the use of a referendum. The referendum is opposed on the basis that it's neither the Commonwealth norm nor a Fiji norm, and the particular supermajority requirement of referendum has been crafted to be impossible. So let's accept, for the purposes of the conundrum we're in, that the supermajority requirement has indeed been constructed, deliberately crafted, to use their phrase, to make it impossible. Let's just run with that for the moment. problem I think the court needs to think about in terms of the approach advocated for by the NFP is that it fails to acknowledge that the outcome it advocates for would provide weaker protection than previous Fiji constitutions, which required bicameral two-thirds majorities, a number of which had extra special protection for particular parts of the constitution and particular laws. The approach the NFP advocates for is inconsistent with the recommendations of the Guy Commission, which suggested there should be a two-thirds supermajority requirement, but acknowledged that having an explicit mechanism for involving the people in the constitutional amendment process would not be a good thing, and recommended that there should be a National People's Assembly, which would be required to be put in place and would be required to participate in constitutional amendment discussions. And if you want to find the reference to that recommendation of the Guy Commission, it's in my principal submissions at 94.3. And lastly, the NFP position overstates departure from the Commonwealth norm. I made reference in my written submissions to an article by Guy Powells, I think the junior, rather than Sir Guy, I'm right, who's an associate professor at Monash. If it is Sir Guy, then it would have been. It is possible because the article is from 1992, 22 Victoria University Law Review 63. I can have a copy of that made available to the court because you may find it useful and instructive. It is, of course, dated, but what it does is it provides a very helpful overview of constitutional amendment provisions in the Pacific.
But the other thing that attracts me, why I'm not interested in hearing that only things should be decided by MPs, is because in this part of the world we have a concept called talanoa, which is a form of people getting together and discuss what's best for them, whether it is at the lowest level of socio-organization or even, in Fiji's case, a provincial level and even wider than that. I'm finding it absolutely impossible not to involve anything to do with constitutionalism and not involve the people that affects them. And I mean, that's the reason I've been very difficult in the last 2 days.
Yeah.
There has to be some connection. And yet I share the NFP's worry about if you entrust it too much in the kind of formats we've had, because we've had some of these before and we see how people play games.
Quite, my lord. And could I make a couple of observations, bearing in mind, remember, I'm not an advocate for one side or the other. My job is simply to test and make sure that everybody sees that some of these things have been tested. Is that in order, my lord? So there's a number of, so the first point I'd wanted to make is that if you look at Guy Powell's article, and I think it is instructive, and I would like, the resources available to me were somewhat limited. I don't have a law firm or anything like that to assist me, but I'm sure the registry would assist in providing, making available a copy of the article, which is relatively short. The key part is the appendix, which sets out in very handy form an overview of the constitutional amendment provisions. And if you look at it, you will see that to varying degrees, referendum requirements are found for either generally or for particular amendments of particular parts of the constitutions in the Cooks, Federated States of Micronesia, the Marshalls, Niue, Palau, PNG, Vanuatu, Samoa. So I just want to...
Did you say Samoa?
Samoa,
Yes.
yeah.
I didn't think there was a referendum requirement in
Well,
Samoa.
that's the case for particular provisions.
Yeah.
So each one varies, sir. And the point I'm trying to make, which is to go back to the point that His Honour Justice Arnold quite rightly pulled me up on, I was going to come to it, but it's important that we have it on the table, is what these constitutions show is that extra special protection, even coming quite close to some of the levels we see in this constitution, are found for particular parts of the Constitution because it recognizes that certain parts of the Constitution need extra special entrenchment.
This is the reason why the earlier Constitution of Fiji listed the issues that can only be, that are entrenched, but not everything. My difficulty is this one. Even to change a comma, we need to go to...
And that's the conundrum, isn't it? That's the conundrum, sir. But equally, remember, what I'm trying to do is test or enable you to test the options that have been put before the court so that you can then assess, well, so what do we do with that? What do we do with that?
Dr. Butler, I can, if it
Your
assists
Lordship.
you, I can tell you that Professor Powell's paper is available on NZOII on a Google search. I'll just pull it up now, so you don't have to worry about talking to the registry.
Thank you, sir. And I had written down here, tell the judges it's Googleable. So Your Honour got there. So I'm just wanting to work through the NFP. So the Human Rights Commission, in their very helpful submissions, say, well, look, one step that you can take is, at least for the moment, adopt the better meaning. And I'm going to refer to it as better meaning 2, because I define better meaning as dealing with the interpretation of 160 sub 2 and 160 sub 6. But as you'll have seen from my reply submissions, I adopted the approach suggested by the Fiji Law Society to the correct interpretation of section 159 subsection 2C, which I think is plainly correct. So I'll refer to that by shorthand as just better meaning Mark 2, 2.0. So they say you should adopt better meaning 2.0, but that there should be a process for developing amendment provisions that would allow for easier change in order to make the Constitution workable, more democratic, and responsive to people's will and changing circumstances. And that was in the supplementary submissions, the oral submissions that you heard from the Commission yesterday at their paragraph 3.5. The Human Rights Commission, as you would expect, and drawing on the idea of extra special protection, has suggested that there needs to be extra protection, not normal entrenchment, but extra protection for human rights and indigenous rights. And it appears to suggest, that's how I read their submissions, but I may be wrong, and they'll come back to it perhaps in reply. The Commission appears to suggest that it would be for the court to say what processes are needed and what outcomes should be achieved. That's how I read their submissions. I was trying to listen. I just didn't have the transcript in order to triple check that I'd heard them correctly, so I apologize if I am mishearing their submissions. And so the point I'd wanted to raise or draw from their submissions is what they are saying is there's an interim step the court can take. On an interim basis, at least adopt better meaning 2.0, but also flag or signal that there can be / should be processes to work towards better amendment provisions to address that conundrum. And effectively, this court, my words not theirs, give permission for such a process to take place and guidance as to what that process would look like. And so then, what I'm trying to do, hopefully Your Honour, Your Lordship see what I'm trying to do, is just to draw out of each of them what might be attractive about them, but also equally what might you say, is that somewhere where we can go?
Can I pause there? The only constitutional provision that I'm conscious of that's similarly restrictive is that in Mauritius that was involved in the case that went to the Privy Council.
Yes.
But that was
Koirati.
yes, that was confined to particular provisions.
It was, that's right.
And it had Mauritius constitution had a somewhat happier backstory than this one.
It did. That's exactly right, sir. And I was going to come and talk briefly about Koirati, but Koirati is
Koirati is taken in the basic
exactly.
concept.
Could I come back to Koirati? Because I think it is important again, because it's a case like Koirati, which is why I wanted to make it heard loud and clear through this process that making some parts of the Constitution difficult to amend is not itself objectionable, and in fact would be upheld by a court. And indeed, if one wanted to go somewhere with a basic features doctrine, one might say that an expected basic feature of a Fijian constitution that wants to be recognized by an independent judiciary of Fiji is one that respects the special entrenchment of, for example, fundamental values. For example, just seeding ideas that may or may not, and then the question becomes, how does that get signaled? Is that a task for the court to undertake or not? But I think it's very important that the court not say that special protection for parts of a constitution like fundamental values is objectionable. That would be a wrong impression for people to take from this hearing, which they could take if they were listening to submissions pitched at quite a general level. That's why I say we've got to get down to brass tacks when considering how to analyse the issues before us and how to respond to them. Does that make, sorry, I shouldn't say does that make, Your Honour, see where I'm going? So the Law Society and the Labour Party say, look, all you can do is adopt better meaning 2.0. You should otherwise uphold Chapter 11. We don't know whether in fact Chapter 11 is an obstacle to amendment in the future.
Well, we can infer that it is, though, I think.
And so the point I was going to make was that's their submission. Of course, their submission is based on the better meaning, so what the court would have to do is assess whether or not, even on the better meaning 2.0, whether that is too restrictive.
So we were to think that the purpose of Section 160 was in fact not to facilitate amendment, but frustrate it. The interpretive arguments you advance are sort of predicated on what you might call a genuine purpose, that is a purpose to facilitate in a practical way the amendment of the Constitution. Now, there are quite a lot of indications that that actually wasn't the purpose.
Certainly, sir. But equally, and one must be fair, there are other indications to, if one is drawing on parts of the Constitution, to rely on those to effectively query the purpose of those provisions.
The purpose of the amendment provisions. I mean, if they were, but it's none of these things are critical, but they came out of the blue. They have no precedent in Fiji. There's not the slightest indication of any attempt to consult with the public on it. There's not the slightest indication of any attempt to test the practicality of the requirements, and still sticking
no explanatory notes given.
And still sticking in my craw is that they were imposed by people who were quite happy to impose a constitution without undergoing any democratic process. So there was a fair bit of hubris in this.
And one could add to that
Indeed.
The very similar, I think almost identical amendment provisions in the Mauritius Constitution in relation to those fundamental features were introduced through a parliamentary process.
That's correct.
Where it was quite explicitly made clear that the members of Parliament thought it almost impossible to amend them in accordance with those provisions, and that was deliberate.
That's correct, sir.
So it was almost like having a no amendment provision.
It was, sir, and and that again is why when I say when the court is thinking about how it defines the conundrum, I think it's this imposition idea that it lies at the heart of the challenge. It's so hard to amend, and it was imposed. It's not like in Mauritius, where it went through a process where presumably, I don't know all of the backstory to it, but I have read the speeches as recorded in both of the judgment of the Privy Council, but also what was said. I've read the Supreme Court of Mauritius decision as well, which goes into more detail and gives quite a useful insight into that background, but it was voluntarily adopted. So the only people who can complain about it isn't the current generation that passed it, but the future generations that may not like it. All right, and that's an issue, that's the intergenerational issue that arises out of hard to amend constitutions such as the Australian Constitution, such as the American Constitution, such as, for example, the Danish Constitution, only amended 4 times since 1849, and think of everything that's happened in those years. The Japanese Constitution, which was imposed, never been amended, since 1946, never amended. But the important thing, I think the important point of distinction that Your Honours have brought out in the exchanges is don't look so much at whether it's difficult only, you have to see how it came about. And so Your Honour has landed on the point I was going to draw from what the Law Society and the Labour Party have said. They say the court's role is limited to a narrow reading, and they may be right. They may be right that that is all the court can do. I'm not foreclosing what the court may say. But the issue is does that narrowing approach resolve the conundrum? And what I'm hearing, if I'm allowed to, Your Lordships, I'm hearing no. That may not go far enough to resolving the conundrum.
What do you think about simply, I'm not the greatest exponent of international law, but what do you think about...
That's true.
Yeah, so it's a late conversion, but what do you think about going to Article 1.1 of the ICPPR and asking ourselves whether the Constitution meets the self-determination requirement?
It's an excellent question,
and
sir.
If of the view, then saying, well, crikey, Article 1.3 applies to us as it does to all other state actors in Fiji, and we've got to try to make it fit.
Certainly, Your Lordship. I was going to come on, because one of
Right.
the...
Okay.
No, sir, I might as well deal with it now, because it's a good... I just had wanted to indicate it's something I was going to come to, and I'll therefore skip over when I come to it later, because it goes to, I think, the questions, that part of question 3 that was put to Council yesterday by way of the minute. You know, what are the criteria that we would apply in deciding what we should do? So a couple of points need to be made. Your Honour, Your Lordship picked up on it yesterday, which of course is that Fiji became a party to the ICCPR 2018. This constitution was adopted in 2013. So one might say the use of a later international covenant to assess the validity, for want of another term, of...
Not really assessing the validity of it, guiding our conduct. So on this basis, it has a here and now application. We're not applying it retrospectively,
Yep.
at least obviously.
So that being so, then the next gradation in the argument would be to say the use of international law to defeat express terms in a constitution is not what the purpose of international law is.
But it may be to guide whether we recognise these laws imposed undemocratically and without lawful authority as being effect, notwithstanding that, their origin, which is a slightly different question.
It is indeed, sir. And so the next layer of the onion, so as to speak, is to come down and say, all right, so let's...
There are quite a few layers.
There are quite a lot. I've been going through them all last night. I'm looking tired for a reason. So the next layer of the onion, sir, is to Your Lordship rather is to acknowledge what you said. It could be something that informs our understanding of the common law, and particularly the formation of the rule of recognition that might apply. So one of the issues the court will have to think through, it seems to me, and this is why I was listening carefully to what my friends for the Human Rights Commission were saying yesterday, is that if you take Article 1, the self-determination right, to its full extent, to its proper extent, I would submit, then in fact the common law rule of recognition should be that no constitution that has not been adopted as a result of popular endorsement or adoption should be recognised by the common law. That actually would be the right way to give effect to the principle of self-determination.
True, I suppose, but one can say as long as the Constitution can be democratised so that a right of self-determination is built into it, then it's okay.
And so that's where I got to last night,
Right.
sir, in terms of working through, is what the court will be looking to do. I think what the court could legitimately think about doing is understanding the common law rule of recognition in that narrower way, potentially, drawing on the principle of self-determination, not to defeat the successful revolution and the constitutional order that it has created, but simply to soften elements of it that would inhibit, over time, the democratization of the Constitution.
We're looking through the prism of a common law process of recognition and how that common law approach is best adapted and applied to the circumstances of Fiji. And I suppose if one looks at the International Covenant on Civil and Political Rights, most of those, I think, have translated into customary international law, which of course can be used in the development of the common law, and at least as an evaluative factor relevant to the question whether there is recognition, if so, the extent of the recognition.
Your Lordship, if I can pick up on that with a number of observations which I hope may be helpful. His Lordship, Justice Young, will tell you I am an early convert to international law and international human rights and how it can apply and should apply in the context of constitutional law. I probably wouldn't be able to go as far as Your Honour invites me to by suggesting that the content of the ICCPR represents customary international law, because I'm not sure that the case law would support going that far, much and all as I would like it to.
Well, I think there's a bit of recent commentary to that effect, but we needn't worry.
But we needn't, exactly, I was going to say, so I'm just, again, doing my job, so as to speak, and just qualifying that. But within that qualification, I think it is fair to say that the principle of self-determination would be regarded as a principle that customary international law would recognise. That's why, for example, invasions and such like are regarded as being contrary to customary international law. The use of the self-determination right or principle to hold that the content of a domestic constitution adopted in suboptimal conditions, that recognition should be withheld. I'm just not aware of a case that has held that. But I can see the argument in favour of saying...
We're not in the area of helpful precedent here.
No, we are not, sir.
We're in the area of what is a principled approach
Correct.
to the development and application of the common law suitable for Fiji. And with respect to what Mr. Moses said yesterday, and I put to him in our last exchange, an approach which doesn't create an open slather.
That's right, and I think that is where I'm coming at it from as well, because it will put the court in a most awkward spot if the principle is understood as being any wider than what it should be. That's why I made the remark I did to His Lordship Justice Young about how careful one needs to be in the use or the deployment of the principle of self-determination, because otherwise it could end up producing a rule that's contrary to that which has been used by the common law for such a long time in terms of recognising the success of a revolution.
One option is to create, say, a list of relevant factors, with none of them necessarily being determinative. But the question is, what's the overarching principle which you use in... You don't just have a whole set of factors and say, this is the impression that emerges, therefore... And it's, I suppose, the formulation of a qualified recognition principle that would be important.
That's right. That's right.
For us, the ICPPR is not just customary law, it is actually part of our law now.
That's right.
Section 51.
That's right. But the point that will be made, and I think a point that will be fairly made, Your Lordship, is that international law has been adopted through domestic processes, but not with the aim of undermining the Constitution itself.
But if the Constitution is itself the result of a democratic process, then it can be said to be the exercise of the self-determination by the people. So this, I suppose, postulated resort to Articles 1.1 and 1.3 isn't really a mechanism for unravelling constitutions that have been in place and accepted by democratically.
Correct, sir. And if I could, just to draw that point out, because this is where the narrowness of a ruling is going to be so important. The reason I was resisting in the way in which I did with respect what His Lordship, the President of the Court of Appeal, was putting to me is, if one accepts a broad principle that effectively inconsistency with the ICCPR is a problem, then how might that be deployed, for example, in terms of assessing the compliance with the ICCPR of some of the Bill of Rights provisions or some of the other provisions elsewhere within the Constitution. Is that
But we people do that already, mainly with interpretation rather
Exactly.
than saying, let's put a blue pencil through this one.
correct? And I'm trying to make that distinction. So the use of international human rights law in order to interpret effectively or properly understand the human rights norms, that's entirely legitimate. That is the common law method in action. There's nothing unusual about that. But the use of the ICCPR in order to effectively invalidate, let's just call it what it is, or render inoperative particular provisions of the Constitution, that's unusual. The only example I could properly find was that decision from Honduras, which relied on the international covenants to get rid of presidential term limits. A very controversial decision, as your honours, as your lordships, I'm sure will understand, which brought the judiciary of Honduras into major political controversy.
Argument in Prasad that the
Efficacy.
test should include a question whether the new regime acknowledges international human rights obligations that the country has signed up to. And the court did not accept that
That's correct.
argument.
That's correct.
Now, what we're talking about here is perhaps a little different, but we need to be conscious of that.
Yes, sir. And that, again, if I can just tie back why it's relevant and why I responded the way I did to His Lordship Justice French, to His Lordship Justice Young, and to His Lordship Justice Tanga, is the rule of recognition understanding is agnostic as to how good or otherwise the legal regime imposed by the successful revolution usurpers are. That has been, that's why I described as warts and all.
Yes, generally, well, we'll come back later, but are there any cases that say it's warts and all?
No practice suggests it's warts and all, and that's what that's I suppose is the question before this court, is whether in fact the implicit assumption of warts and all is something that could not be tested or explored because, for example, you might say it just simply never arose for consideration in those earlier cases.
A possible exception to that, and I haven't got all the cases clear in my mind, is the general reluctance of courts dealing with cases of this sort to regard themselves as constrained by ouster of jurisdiction clauses. So judges, and I think Prasad, in a loose sense, I don't know that there was an ouster of jurisdiction clause there, but in a loose sense, the similar argument about being sworn in under another constitution.
Yeah. Well, Prasad, of course, what was interesting about Prasad, and I emphasised this in my principal submissions, I was picking up a point that was made by Venkat Iyer in his commentary on Prasad, a very interesting and useful article. I mean, he's talking about coups generally, but what he emphasised was that what was interesting in Prasad is that the judges who were considering that case were operating under the oaths that they had made to the 1997 Constitution. And it was a deliberate decision had been made not to require them to swear allegiance to any new administration under the Administration of Justice decree that was adopted by the usurpers, so that they could be faithful, and I have the pinpoint citation is in my principal submissions. It's at the beginning of my principal submissions. So the judges could.
But they were still being invited to treat as abrogated the constitution to which they had sworn an oath, and they were not deterred from engaging the case by reason of that sort of consideration.
Quite. But legally, it was easier for them to continue their allegiance to the constitution that they upheld, so as to speak, because that is the constitution to which they had given allegiance.
Well, we have a similar paradox. I mean, the question E, or the fifth question, as I understand the constitutional arguments, we can answer it if we're of the view the Constitution's been 1997 Constitution's been abrogated, but we can't if we were to give the different answer, which. Maybe
it's a tricky
too
one.
Paradoxical for me.
Indeed. And just while I'm on the oaths, Your Lordship. One of the points I made in my written submissions, because nothing here is easy, and me just doing my job, pointing out, well, there's a weakness here and there's a weakness there, there's a strength there, there's a strength there, is that if you look at the oath of allegiance or the affirmation that the judges take, it is to the Constitution and the other laws of Fiji. Which includes the common law and is potentially the gateway through which one goes in terms of the rule of recognition.
Now, on the rule of recognition and the warts and all issue, if efficacy is the exhaustive test, does it follow that it's really warts and all recognition?
Yes, it does. And I was in agreement with what I heard from my friend Mr. Moses yesterday on that point. Yeah. I think that is the correct.
The question is efficacy the exhaustive test?
Exactly, correct. Or is there an efficacy light or an efficacy exception? There's any number of different labels we can give to it, but it is an important question to be asked. Your Lordships, other interveners have suggested that what the court should do here is declare the 1997 Constitution to be the only legal constitution. The court should, having said so, uphold the validity of conduct done under the 2013 Constitution on the basis of the doctrine of necessity. And the court should then signal pathways for the restoration in practice, de facto, of the 1997 Constitution, including its amendment provisions, I apprehend. So that way of resolving that conundrum is our back to the future approach. And that would require the court to accept the proposition that the 1997 Constitution is still in force, that the purported abrogation of it on the 10th of April 2009, and everything that happened since with all the other decrees, the introduction of the 2013 Constitution, the adoption of laws since 2013 by the new Parliament, by the parliaments, successive parliaments created by the 2013 Constitution, the recognition of the 2013 Constitution by Parliament itself through its standing orders, the recognition of the 2013 Constitution by this court by proceeding on the basis that it has been valid and making rulings on the basis of it, and the recognition of the 2013 Constitution by public officers, military, police, other public officials. All of that should be set aside and the 1997 Constitution restored.
And you get to that position in the exercise of the preliminary jurisdiction of the court, that is determining whether it has jurisdiction, which it only has if the 2013 Constitution is recognised. So you get to the point of saying, we don't recognise the 2013 Constitution. That leaves in place the Court of Appeal decision about the 1997 Constitution. Maybe make a declaration, we all go home.
And I think that's the logic, as I understand it. It wasn't expressly stated so, but I think what's been very helpful, if I may say, about the exchanges between bench and bar over the last 2 days has been, I think we've been able to flush out some of the legal supports for the particular propositions that have been adopted. My response in relation to that, your Lordships know I adopt probably a narrower reading of jurisdiction under 91.5 and 98.3c, which I am going to come to if I have time. But I say that you can exercise your original jurisdiction to give advice as to the proper interpretation of the 2013 Constitution and as to the application to facts stated in the case stated, because remember this is a case stated process according to the Supreme Court rules. So you say how it is that the 2013 Constitution applies to stipulated facts, as you did in the 2024 reference. And I say you can undertake that task without having to approach the anterior question of whether or not the 2013 Constitution has been validly promulgated or not. You just asked, what does this document mean? And how would it apply?
What's our authority to do that?
Your authority is the terms of Section 91.5, because you only get jurisdiction by Cabinet asking you questions around the interpretation and the application to particular facts of the 2013 Constitution. So, just completing the thought, sir, when this court convened and answered the reference last year in the 2024 reference, it proceeded immediately to doing that which Cabinet had asked it to do, namely, how do we interpret the relevant provisions related to the status and the appointability of judges? And in light of that interpretation, how do those provisions apply to these particular appointments? You don't have to go and ask, and it is not part and parcel of Section 91, sub 5, that you ask yourselves each time, have we got anterior authority based on the legality of the 2013 Constitution?
I don't see
No.
how you can avoid that question unless it's already been answered definitively by the court on an earlier occasion.
I hear what Your Honour says, so Your Lordship says, and I'm going to resist if I'm allowed to, so that's expressing my opinion. I think when you look at that section, what is just...
A West Australian judge was once told by counsel that he heard what the judge was saying and responded, yes, but are you listening?
I understand, Your Lordship. So, and obviously, I understand obviously, I understand the notion of jurisdictional base, etc. My point simply is, when we're looking at this provision, recall the advisory jurisdiction is not the only way to get an answer about the contest between the 1997 Constitution and the 2013 Constitution. There are other mechanisms, other forms of procedure that can be used. Prasad, Ngarase, those were cases that commenced in the usual way. High Court, Court of Appeal didn't go higher, but through trial processes. And so the submission I'm making is that you don't need to worry that that issue cannot be explored, but is a case-stated procedure the right way of resolving that? You heard in the oral exchanges on day 1 and day 2, various members of the bar giving, and I'm not being critical about it, but evidence from the bar about their experience on the ground, protests, etc., etc. You just don't have the material before you to assess whether or not what has been said is correct or not. You don't.
Dr. Butler, time-wise,
Yes, sir.
how long do you need?
Sir, I
to
want...
complete your submission?
I want to come and talk about what the court can do to resolve the conundrum. I think you
How long
need...
do you need for that?
If you want me to do a proper job, getting down to the brass tacks, because we have not got down to the brass tacks at all in this hearing. We've talked at the generic level and you need assistance on brass tacks. I think you ought to give me 45 minutes to be able to do that with you, to enable you to have meaningful exchanges with me to test.
45 minutes, no, try and reduce it. It's not necessary to go to 45 minutes.
Good? I will try and reduce it then.
30 minutes?
30 minutes? I'm assisting you. I'll take whatever time you feel is helpful to the court.
Thank you.
So, the court's role in resolving... I should say, just before I complete, so they know that I heard their submission, so the Serioratu faction says you should uphold the 2013 Constitution and its amendment provisions. That faction says that the amendment provisions serve the important purpose of avoiding opportunistic or destabilizing changes. That was in their oral subs at paragraph 4. And that's certainly a perspective that is offered, because I think the words you might use is to say, well, what the amendment provisions mean is that the people of Fiji have strong protection, very strong protection for the rights expressed in the Bill of Rights. They have strong protection for separation of powers. They have strong protection for the fundamental values set out in Section 1, 2, and 3, and such like. So it's important, I think, that that perspective be acknowledged and put before the court. But it doesn't resolve, I don't think, the conundrum, if I've correctly identified or using the right label, that I apprehend the court feels it's confronted with. So what is the court's role in resolving the conundrum? Well, first of all, you've got to agree there is a conundrum. And you've got to, in my submission, form a view as to whether Chapter 11 should be read strictly, as my friend Mr. Walker for the state has argued, or narrowly, as I have submitted and as a number of the other intervening parties have supported. That's the Law Society, the Labour Party, the Human Rights Commission, and as an alternative to setting aside the supermajority requirements, the NFP would come on board and say, well, that's an alternative. So the question then becomes, if the court does adopt better meaning 2.0, is that enough to address the conundrum? Or, more pointedly, is that as much as the court can do? Or, even more pointedly, is that as much as the court should do? Another option is the court can acknowledge the conundrum but take the view that it is not its role to resolve it, other than through adopting better meaning 2.0. My friend Mr. Moses referred to Southeastern Drainage Board as an example of where, if in the same document you have provisions which pull in different directions, you can't just take one out, you've got to work to reconcile them, and that would, better meaning 2.0 would be an example of a way in which that could be done. A view that might hold favour with the court is a view, for example, expressed in cases like Zuma, Matadine, and Pinder. Pinder is in my reply submissions, and I'll have a copy of that provided to the court at the break. It's one of the cases I described as wince-inducing. It's the case about flogging in the Bahamas, which was upheld by the Privy Council on the basis that, distasteful and all as the punishment might be, and its inconsistency with
existing laws reservation.
Exactly, it was preserved by the savings clause, and it was the job of the court to uphold it even if it did not agree, which plainly it did not agree with what was being done. And there are strong cautions in Pinder about what judges do in the constitutional space. And it's my job to draw those to the court's attention because they are salutary and they're a reminder of constraints, let's put it that way, that other judges have recognized. Another approach, which I'm going to call the extramural approach, is the application of non-recognition of Chapter 11 by the common law rule of recognition. So it's extramural because it's happening not from within the constitutional text, but from outside the constitutional text, relying on an external principle being the common law rule of recognition. And that would require the court to say that the rule of recognition is not simply focused on efficacy of revolution, pure, but that the rule of recognition allows you to do two things: recognize general efficacy, yet at the right point in time, withhold recognition to particular parts of that successful revolutionary order. Now, here's where I'm talking about getting down to brass tacks. If the court were going to do it, not only does there need to be a principle basis upon which for doing it, why these particular provisions we won't recognize, but these ones, even though we don't like them, we will recognize.
In the way of democratization.
Exactly, and that would be the principled approach. So there's your principal basis for saying, here's why I would recognize some but not the others. So the question then becomes, so what do you do in order to give effect to that non-recognition.
At a high level of generality, one can speak of the Constitution having regard to its history as having what I've described earlier on as a democratic deficit.
Correct.
And the question is whether recognition can be qualified so as to allow, with minimal intervention by way of non-recognition, a feasible or workable repair process.
Correct. So when I say correct, so that I'm coming to, along those lines, because I think the brass tacks question asks you, okay, if the court says it's not going to recognise Chapter 11, that's a big call, and that's the call that you've been invited to make by the state. But it has the problems, in my submission, that I've pointed out earlier. It means that your decision not to recognise Chapter 11.
Well, you need a scalpel rather than a machete, perhaps.
Exactly. That's exactly right. And so then once you're taking out the scalpel, the question then becomes, what do you excise? And what is the jurisprudential basis?
We're not necessarily confined to excision.
In my submission is the tricky part of what it is that a court does. Could we just examine what I might mean by excision and what Your Honour might mean? I'm not confined to excision.
So blue pencilling. We're not confined to say we don't like the referendum provision, so we just take out any provision that refers to it.
What you might do instead is apply the blue pen to get rid of 3/4 and take out the red pen and put in 2/3.
Okay. Well, I would regard that as sort of reconstructive, I suppose.
And so that's what I'm seeking to explore with the court, because blue pencil, so I'm a parliamentary draftsperson, blue pencil you'd use, take it out, red pen to add something in. So we're used to the idea of a court, through the reading down principle, applying blue pencil. That happens in all of our jurisdictions all the time, Australia, to make sure that a statute conforms.
It's written into the
interpretation.
Section 15A of the Acts
Exactly,
Interpretation Act.
the Acts Interpretation Act, Section 15A. So there's a statutory mandate for it, but it's entirely conformable to practice prior. It's a well-known principle in New Zealand as well, reading down, and certainly I know it's been deployed in Fiji. The harder part is not just to read down, but it's to read in, because that feels more constitutive. But if what the court is minded to do is to adopt the scalpel approach, my submission would be that is the right way of thinking about the relevant techniques of interpretation that should be applied by the court. The principle that should be applied is the principle of minimal interference. So when reading down, I've been looking overnight, but I haven't been able to find a text that makes what I would have thought a principle 101 that you would do of reading down. Namely, the reading down principle is applied to do the least amount of damage to the statute, or here the constitutional provision that you are seeking to read down. What is the minimum necessary to achieve compliance?
It may be that reading down is the wrong term in this context. It may be that the better term is selective non-recognition. And then the question is, what does that involve? Is an incident of that? For example, could one say that 2/3 is a lesser part of 3/4?
This is why we're in brass tacks. Because that is where, once one moves from the general principle, the concern, the actual implementation of it, that's where, again, we come back to what a court does and what is the proper exercise of judicial function. So the submission I make is that if what the court is trying to do is express a view, advice, because all it's doing is advice, is that we will not...
No, at this stage, it's the substantive question of recognition. Once you've recognised...
yes.
Then you get into the answers to the questions, which will follow almost automatically, I would have think, from the scope of the recognition.
Yes, I see what your lordship is saying. That's right. But even then, even at the rule of recognition level, as a common law court, there are challenges, are there not, associated with the idea of how you would express.
Well, you would make declarations, wouldn't you?
Yeah.
In the-
And so the declaration would read, the court does not recognise Chapter
Exactly
11,
right, yeah.
but, ...
Or recognises to the following extent.
And so I think that formulation becomes quite important. So it's not excision as such, but rather saying what it is that the court will be prepared to recognise. And then, of course, the people of Fiji, if that power is available, the
It's
power
over
that's
to them.
recognised, it's over to them to do with it what they will.
Yeah.
But I hope you're honest, that engagement has been helpful to try and figure through what in brass tax terms, actually how one would give effect to the rule of recognition here, because it seems to me it's quite important, because the general principles that the court should adopt are minimal damage, harm, change, might be a more neutral term.
Minimal intervention.
Minimal intervention. Minimal intervention. To achieve the purpose which animates the non-recognition of what is currently there. And so the question then I pose is, in terms of if that's the approach the court was minded to adopt, the question then becomes, what impact might that have? What it means, I think, is the court would need to be relatively specific as to what. Can I just pluck some numbers out of the air just for working purposes? Let's say the court says, well, 3/4 is just too much of a referendum, and 3/4 is just too much of MPs. It should be 2/3, that's the minimum. You may not agree, but I need something to work with. 2/3. Is it 2/3 of all MPs? Is it 2/3 of all voters, or those who vote?
All we have to say.
I think the court does need to say, because we need to know that if the people of Fiji are going to exercise their constitutional power to change the constitution, they need to know when that threshold has been met. And there's divil in the detail there, which is my point about the brass tacks. So I just want to explore one or two other options that the court might have in light of this detail that we're working our way through. It seems to me an alternative analysis that the court could adopt, it would be something drawing on. There's not an exact analogy, but there is a way of thinking about it. Is to draw on the approach of the Supreme Court of Canada in the Manitoba Act reference, which is one of the cases I included in my principal submissions, and has been talked about, interestingly, by Professor Hogg, the late Professor Hogg. The Manitoba reference case and copies, I think, have been provided, am I right, to the court? Oh, they're being provided to the court. Well, let me describe the case while it's being handed up, and copies have been provided to my friends, including a copy of the article by Professor Hogg. The Manitoba Act, 1870, Manitoba was part of what was the Northwest, from memory, part of the Northwest Territories. Anyway, it was one of the early provinces that people moved into. At the time that Manitoba was created, it had a substantial French-speaking population, as well as English-speaking population. The Manitoba Act, which was the provincial constitution, required laws to be made in English and French. From 1890 onwards, the English, who had become the dominant majority, decided that we're not going to respect that principle anymore, and they passed legislation to stop that. A number of cases over the years determined that that was inconsistent with the Constitution, but the provincial government just boxed on regardless. In the late 1970s, a case was taken where a declaration was made by the courts that this is just intolerable, this is a breach of the Constitution. Ultimately, what happened was, with a lot of faffing around, to use a technical legal term, a reference was made by the Manitoba government and the Canadian government to the Supreme Court to figure out, is there a breach of the provincial constitution here? And if so, what do we do about all the legislation that has been passed since 1890 in breach of this constitutional requirement? Supreme Court of Canada said, yes, it is a plain and clear violation of the provincial constitution, which you knew about for a long time and decided to ignore. It calls into question the validity of the Manitoban legislature, which did not look anything like what it should have looked like. It was, all the changes were made through an English language legislation, etc., etc. So having said that those pieces, those acts of Parliament were invalid, so it's important that the finding of the court be acknowledged. Those pieces of legislation were invalid because they were inconsistent with the terms of the Manitoba Constitution and the language rights guaranteed. What to do about it? So what the Supreme Court did was it said those laws should be treated as having temporary, ongoing validity.
This is a bit like their doctrine of prospective overruling,
Yes.
which Australian judges have a difficulty getting their heads around, I think.
And that's why I very tentatively broached it, sir, because I'm very familiar with the fact that in the Australian understanding of the judicial power under the Constitution is that gets the courts, as I understand the doctrine, gets the courts into a tricky situation, because then they are not only making rulings and making orders, they are being political.
How does this, I mean, from an Australian point of view, I suppose one might say, well, what they're saying is it's invalid, but not invalid until 6 months from now.
Correct.
So how does that help us?
How would
does
that apply
engage
here? So how that would apply here, as I see it, and again, these are just options for the court to think through when it's figuring out what's our role and what can we usefully do in this context. So the resolution of the problem in the Manitoba case was easy. Translate them into French. That's what happened. It's just going to take a very long time to do. And in fact, the case went back a couple of times to the Supreme Court for follow-up orders in order to understand, because what the Supreme Court said was, we'll give you 3 years to make provincial legislation, render that into French, and we'll give you 5 years for regulations, so subordinate secondary legislation. And then questions, they needed more time than what was given. And then they also came back with various questions about documents that were incorporated by reference. Do they need to be translated into French, et cetera, et cetera? It's all terribly interesting. But the important thing, it seems to me, about how that would work here is the court could adopt an approach here which says, look, Chapter 11 is contrary to, and this depends on whether you're acting extramurally or intramurally, Your Lordship, could take the view that Chapter 11 is not acceptable. But in recognition of the importance of the rule of law, which is a constitutional value and a common law value, and that's why the Manitoba case repays reading, we cannot have a vacuum. We cannot have a vacuum of the sort, which is effectively a vacuum that has been advanced by the state of amendment by simple majority. So what we will do is we will indicate to Cabinet, and therefore to the public, by our answer, two things. One, an indication that there needs to be a process, without stipulating what that might be, what the exact process might be, a process that would respond to the problem that the court has identified with these provisions, which is not necessarily how hard they are to amend, simpliciter, but the way in which they came about. It's the imposition of these provisions that has caused the problem, that is causing the conundrum. So a process needs to be adopted, which leads to the adoption of entrenchment provisions, which the court would be prepared to recognise. So this is how it feeds back into the notion of a rule of recognition. You could be non-prescriptive around what that process looks like, but indicate what sorts of features it ought to have, wide public consultation, etc., etc. And what doing something like that does is it would suggest that the metes and bounds of what a new constitutional amendment provision would look like is resolved in the political realm, with the assistance provided by the court of saying, well, what we're looking at in terms of Chapter 11 is just not acceptable. And the principle I'm thinking of here is it's easier for a court to be negative than it is for a court to positively put something else in place. So you might think, well, everybody knows a bad meal. Not everybody can make a good meal.
So that means that the court would stop at the recognition process and in some way or other indicate a requirement for recognition of Chapter 11 that involved democratic legitimisation in some way or other left to the people, and then just not go into the questions.
Not quite, I think, sir. I think, and again, just on that, it may be that you don't need to answer the exact wording of the questions, because...
Well, how are the questions relevant if this ends at a conditional consideration of recognition?
Because the questions have prompted, this is why in my principal submissions I took quite some time to work my way through what a reference is and what the practice is in the overseas jurisdictions. So this court, as a superior court, like all superior courts, gets to control its process. You're exercising judicial function, and one of the functions that the way in which a court exercises its powers is where it's presented with questions by parties, or I would submit by cabinet, that don't quite capture or enable the giving of answers which the court believes are the right answers to be given in light of the issues that have been raised. The court can reformulate, which is effectively in some ways what the court is doing through the minute that was supplied yesterday, can reformulate the questions in a way that it is capable of giving a satisfactory answer to the issues that have been raised by cabinet.
So what do you say then to a possibility that we read down to what's perhaps a bit of a euphemism, the majority, a supermajority in Parliament to say 2/3, the referendum majority to 50%? Do you say that's available, or?
That's where I
It has the advantage of sticking reasonably closely to the structure of the amendment provisions and perhaps the underlying thinking, but makes them practical.
It certainly would produce something that's practical, so it certainly would do that. The issue of principle that I would suggest the court needs to grapple with is whether that means that the court strays from being a constitution taker to being a constitution maker. Because you're getting quite specific.
It can't really turn on whether we can make sense of a provision by putting a blue pencil through one or two of the words.
That's correct. So
that would be a very strange restriction on the power of the jurisdiction of the court.
And to be very clear, I am raising the issue about, normally it's blue pen, but the court might take the view that in the extraordinary circumstances that confront it, in light of the view it might form in terms of rule of recognition, that this is one of those rare occasions where it's appropriate to have two coloured pens. But
the term constitution maker versus constitution taker might be thought to overlook the fact that the common law is part of the constitutional framework of Fiji.
That's correct, sir. So I'm working with that proposition, but simply saying acting judicially, if I can put it bluntly, is also part of the common law. So the question I'm raising is, by what criteria does one say, for example, that 50% approval at a referendum is...
Because the exercise as to or a decision whether there has been an effective right of self-determination left to the people of Fiji calls for an evaluative exercise. That if we are dealing with the concrete language of a constitution, we have to come up with particular words which represent a sort of a balance of where we get to on that evaluative exercise. Why does someone get awarded $70,000 when there's actually a range of 60 to 90?
Correct. I accept that, sir, but I go back then to the animating principle that in the exchange I had with His Lordship Justice French about doing the minimum necessary to allow a voice for the people of Fiji in determining their constitutional future by means of constitutional amendment. So that all I am raising with the court is...
Do we have to cut it back to the very minimum extent that the framers of the Constitution could have provided for without running into a rule of recognition reef?
Well, this is where other data points, such as the provisions of the other Pacific constitutions, I think are useful for the court in terms of it being able, because the court, in my submission, needs to be able to say, we have done the minimum necessary to respect the self-determination principle, if that is the principle which is going to inform our view of the rule of recognition.
Why not give it fulsome recognition, to use a word that's changed its meaning in my lifetime? Why should we give it a grudging recognition, the least recognition we can get away with?
Because you're a court, and you are not constitution makers, you are constitution takers. That is the answer,
Yeah, okay.
which Your Lordship may disagree with, but that is the animating principle.
Okay.
And that I would caution the court that if there are to be coloured pencils applied, that it do so in a manner that does the least change necessary to give effect to the issue that animates it. The issue here that animates it is these provisions were imposed and mean that the people of Fiji are restricted in their ability to have an effective, meaningful voice to change their constitution. And one of the reasons that you might say that that is the right approach to adopt is, for example, we have a unicameral parliament now rather than a bicameral parliament that we used to have. Therefore, 2/3, for example, is more difficult. So what, in other words, you're looking to do is strengthen a range of different requirements to make sure, not that they're exactly the same, but that there is an equivalent sort of protection that's available. You might say, well, look, we wouldn't want fundamental values to be able to be set aside by a 50% majority at referendum unless that is something that the people of Fiji wish to get to. So the minimum intervention would be 2/3. And you could justify that by looking to some of the other data points, such as the other Pacific Island Amendment provisions. Because I think the court needs to be mindful that it is a judicial body, not a constitution-making body. The rule of recognition is, of course, a common law doctrine. It has to be exercised carefully and sparingly so that no one has the perception that the form or shape of the Constitution is one which is to the judge's satisfaction, as opposed to something that deserves to be recognized by reference to common law principle. I would just remind the court that, for example, in Prasad, to which there's been quite some reference, that in the very first paragraph of Prasad, not this court obviously, but the Court of Appeal said, we have no jurisdiction or authority to pass judgment on non-legal questions, particularly those of a political nature. So again, one needs to be careful in my submission about how far one goes in terms of reducing supermajority requirements. one needs to be conscious of the acknowledgement in Prasad that it was not the job of the court, this is at paragraph 3, that it's not the job of the court to determine what the best constitution for Fiji is, but rather whether it is lawful. And one should, of course, be conscious, it seems to me, of the points that have been made by a number of the interveners, namely that this question of constitutional amendment has come before us in, if I may say, an abstract context.
Well, we're being asked to basically buy a pig in a poke, aren't we? We know they want to amend the Constitution, but we don't know how.
Correct. And so that would be, from me, sorry, not for me, in my submission, that would be another reason that would justify adopting the minimum intervention approach. Your Honour, Your Lordship, Justice Young, on day one, asked my learned friend, Mr. Walker, about the immunity provisions and whether, if the Chapter 3 were to be set aside, would that mean that the immunity provisions were able to be amended? And the answer to that he correctly gave was, well, if you deal to, again, he'd be far more elegant than I am, so I'm sure he'll excuse me putting it more colloquially. If you deal to section 159 2C, then through that route, you can amend those provisions of the Constitution that provide the immunities and declare the immunities to be, irrevocable and untouchable. And so again,
we are being asked, not very explicitly, but we are being asked to say whether we recognise the unamendability of the immunity provisions. So we can give an answer to that.
no, and
What, sorry, you don't think we can give an answer to that?
again, on a case stated without facts, which will tell you the importance
Or
or
why can't we rely on the legislative fact sort of approach?
because I think the court would want to have a better understanding of how immunities work, what the constitutional history is.
Well, I think we understand the constitutional history. They were there in the 1990 Constitution, the 1997 Constitution. They were a non-negotiable part of the 2013 Constitution. They are not unknown. They're not, said by someone who's not very keen on them, not to be outliers. So they're consistent with Fiji constitutional practice. It's a recognised fact that such immunities may be appropriate in transitional society as smoothing away from autocracy to democracy. So I think we understand the guts of it.
Sir, I'm not disagreeing that you understand the guts of it. I'm sorry if I misspoke.
But so I'm really an invitation as to what are the details we don't know.
How important are they in the context of where Fiji as a society is today, if what one does is you provide a rule of recognition that allows for those immunities to be
Well, it's
amended and
reasonably
questioned?
obvious that there are potential consequences, difficult to assess with precision.
And the question simply becomes whether or not they will become easier to assess if the matter is addressed through trial and appeal and that process where the full picture can be put before the court. You don't have to answer every question on this reference. You're not required to. You exercise judgment and evaluation as to whether that is an appropriate thing to opine on.
Do you
in my
think it would be
submission.
a sensible thing to leave an issue like that hanging in the air?
That I can't say. It has been interesting to me to listen, because in my notes I described it as the elephant in the room, and very much fits that because we have heard not much on the immunities during the 2 and a bit days that we have been going. So I feel as an outsider I'm not in a good space to answer the question that Your Honour has asked. I can just see it's something there. Your Lordships, there were any number of other issues to be addressed, but I see it's that time. If Your Honours have Your Lordships have any other questions, obviously I'm here at your disposal to assist you. I'm not advocating for any party, so I'm just here to help you.
Any other questions? Thank you, Dr. Butler. Thank you very much.
Thank you, Lordships. Vinaka.
Right, do we take a break?
Take a break.
Yeah.
Take a break and then do the reply.
Okay. We'll take a break for 15 minutes. When we come back, and all the interveners will answer the questions been put forth. And that
10
will-
minutes, 10 minutes, 10 minutes.
10 minutes each.